So stay tuned, continue watching. Thank you very much. And cases before the 1st of July 2020, part-time workers to rely on sex discrimination law to try to enforce the same contractual rights as full-time workers. This is because the majority of part-time workers are women, and action has been successful in such cases where the employer has been unable to show any objective grounds why the part-time worker has been less favorably treated. So where the burden of proof would be on the employer rather than on the employee. An example of such cases including part-time workers being targeted for redundancy issues, also part-time workers having to work for more years than full-time workers before being considered for promotion. This is a situation at work. So part-time workers being refused access to a company pension scheme because of being a part-time worker. This is actually a type of discrimination. This is against the law. And it's important to know this, like I said at the opening. So let's look at also part-time workers being excluded from a company's sick pay scheme. These are common situations in the United Kingdom, which is actually either employers doing it knowingly or otherwise. That's why it's extremely important for the government to protect workers from scrupulous employers, which is a common occurrence, not just in the United Kingdom, but across the globe. But this is example in the United Kingdom is available also as an example across the globe, because we are operating capitalism. Like I said previously, if you are always up to this point, you are a champion. Thank you so much for your participation. And I will be continuing along this plane. Leave a comment below and let me know you are thinking about this material and about this topic. And if you haven't subscribed to my channel, subscribe. Please subscribe and then share the video with family and friends, and let me know what you are thinking. We are also looking at workers who were previously full-time being refused the right to return to work on a part-time basis following maternity leave. This normally applies to women during maternity leave. It affects women more than men, if any. If you are a part-time worker whose circumstances match one of the cases about, and you need further information about how to argue a case, you should contact a specialist employment advisor as always. And watch this video and the rest of the video. Some of these material are repeatable, which is okay. And leave a comment below, let me know what you're thinking. And stay tuned, continue watching, and thank you so much for your support, for your participation in this program. And let me know what you're thinking. So we're looking at employment, we're looking at work. Under work, we're looking at employment as a concept of law and policy, and we're looking at people with employment statuses such as found in employment, also worker or similar, the different sexes, but also making claims to a tribunal, employment tribunal, and the process of doing so. So if you are a part-time worker, therefore, and also must employers allow, let us look at a different section, and must employers allow workers to move between part-time and full-time workers? This is a question which is answerable. We're looking at women workers. In particular, the worker is a woman. This is a scenario, this is a case study, returning from maternity leave, and she wants to transfer from full-time work to part-time work, or work different hours, or job share. She has no statutory right to return part-time if she was previously working full-time. However, she has a right to have a request considered seriously and to request flexible working if the employer refuses to allow her to return to work on a part-time basis. She may be able to make a claim for indirect sex discrimination. This is a tricky one in practice. Comment below, let me know. If you know anything to do with employment law and policy, let me know. So also, a woman who is refused the opportunity to work reduced or different hours in order to care for another person like a child or an elderly parent might be able to make a claim for sex discrimination. So more about making a claim for sex discrimination as it is if a full-time worker becomes a part-time worker for the same employer. For example, a woman returning to work after maternity leave, the worker has certain rights. So stay tuned, continue watching. Thank you so much. We are looking at employment claims to employment tribunal for issues which are common at work. And let us stay tuned, continue watching, leave a comment below, subscribe to this channel if you haven't subscribed. And thank you so much. If you're a full-time worker and you wanting to change to part-time work under this situation, and you are being a worker also, a worker who changes to full-time work, from full-time work to part-time work, you will be in a situation with the capacity to compare your terms and conditions under part-time work to those you have under full-time work. So if you are less favorably, then if you are less, if you are less favorable, then you will be able to take action to enforce your rights. It's about really fair treatment. Which if it's missing, then we can conclude unfair treatment, less favorability in terms of treatment, which triggers actually actionable procedures, actionable rights as such, which can be enforceable within the law and within the same policy. So if you are less favorable, then you'll be able to take action to enforce your rights as such. So this applies to a worker returning after a period of absence, for example, going back to work part-time, and also after maternity leave. Again, this may be sex-specific, which is gender-specific, so to say, because normally this situation, this scenario affect women more than men. So provided the worker has not been absent for more than 12 months, you will be able to compare your terms and conditions as a part-time worker to those you have had when you were a full-time worker, and you can take action accordingly if you are less favorably treated by your employer. Leave a comment below. Thank you so much. Stay tuned, continue watching. And therefore, this does not mean, however, that a worker has a statutory right to return to work part-time after maternity leave. This is what it is saying, is that your protection as a worker is less robust than if you are probably an employee who may enjoy statutory protection of under the circumstance where you may want to turn to work from one status of employment, such as full-time, maybe to part-time, as normally is the case when a woman is or someone is actually returning from work, turning to work from maternity leave, which normally is gender specific in terms of practicalities. So looking at public sector workers, under these circumstances, public sector is opposed to private sector workers. So part-time workers prevention of less favorable treatment regulations 2000 based on the EU Directive 97/81 EC on part-time work. Therefore, the laws are quite slightly or perhaps significantly different. If you comment below what you think about this differentiation. So the directive state that wherever possible, employers should consider allowing their workers more flexible working hours. Therefore, by implication, EU directive on employment rights give more right and valuation than national equivalents in terms of law and policy. These requirements can be relied upon directly by the public sector workers. However, this part of the directive has not been incorporated into the regulation, so it cannot be relied on by the private sector workers. That is the problem when you talk about EU regulations, particularly perhaps because Britain has Brexited, has left Europe, and therefore now and increasingly in practice more employers are actually private businesses, which means it's a diluting of the UK law on employment rights, as you can see. So the government guidance which accompanies the regulations recommends some actions employers could take as a matter of good practice. Now, good practice is good and recommendation is good, but we need probably a statutorily based right, so that it is strong enough in terms of regulating especially private companies who are providing employment for the British people. So you could use this guidance to negotiate with the employer of a private sector worker. When you talk about they talk about employee who in practice are actually unable to negotiate with the employer because employers are extremely powerful comparable to employees by the nature of the thing. Therefore, such a policies can be reviewable based on government attitude of the political will to kind of like give more strength to employee as opposed to employer, which is not the case now because of privatization. The attitude of government in terms of politics and also practices, politics and policy practices is to privatize the economy and kind of like treat employer more favorably than employee, which is leave a comment below. Let me know what your experience at work is. So let's look at the public sector as workers, which may include workers of local authorities, as you may be aware, government departments, National Health Service Trust, or in Wales, local health boards, public utility companies like energy, water, and we're looking also at perhaps I mean these are but you talk about public utility. These are private companies providing public services. Maybe even National Health Service Trust are actually public policy providers, but they're actually private companies. So this policy material is really not very honest or maybe accurate in terms of representation of the circumstances. There is an element of truth in it, but more and more of these public sector facilities, especially public utility companies like water, are provided by private companies. So the directive encourages employers to take a positive attitude toward flexible working hours, so it is discretionary upon employees. They are not statutorily obligated. So these effectively in practice dilute the right of employee almost to zero. I'll leave a comment below and let me know you are thinking about this law. I just want to stick with the remit, other than providing analysis, which I will do going forward in this series when the time is right. I'm just trying to set a background to portray how employment law operates in the United Kingdom. So looking at this advice, which is given in terms of policy and law to employer, which gives absolute power to employer. It's up to them really to have a positive attitude. Nobody knows what positive attitude is. In particular, it suggests that wherever possible, employers should consider requests by workers to transfer from full-time to part-time work. There is no legal right per se, but this is a guidance. We simply, give power to employer to decide what they think is good for them, for their business. That leaves the employee without any right at all. So requests by workers to transfer from part-time to full-time work, also to increase their working hours, should the opportunity arise. This is a very weak policy. So also the keeping workers and workers representatives informed about the availability of part-time and full-time jobs. This is very weak. And also talk about trade union when they talk about workers representative, maybe representative within the employment facilitation. This is a very bad commentary on employment law, which favors almost absolutely employer other than employees. So also looking at measures to facilitate access to part-time work at all level of jobs, for example, making job share opportunities more widely available. And if you comment below, let me know what you're thinking. Stay tuned, continue watching. Thank you so much.